there is the underlying and universal notion that punishment must be just and fair, which means that the offender should not be punished more than his offense deserves. It may be difficult to decide what is a fair proportion between a crime and the punishment attached to it, taking into consideration all the circumstances of a case, but there is an assumption that there exists general notions in given community of what is just desert, appropriate punishment. The principle of fair desert is that a person should be punished only if he has actually committed an offense as defined by law, thereby emphasizing judicial precedent, and offenses of unequal culpability should be treated differently. See the case of Maysako v. Superintendent General of Police. 1960, WRNLR 188. In that case, the sentence of one accused was upheld because he had a record of burglary, but that of the other was reduced because he had no previous conviction. Similarly, in Inahora v.R. 1965, NMLR 25 at 283, the court reduced sentence imposed on lieutenant, assistant, because it was heavier than that imposed on the leader. CSS 152. Introduction to Nigeria Criminal LA. W. 88. Thus, the significance of the just desert notion lies in the fact that it acts as a check on the principles of deterrence, which are forward-looking principles, or reform. It may well be added that a punishment may be justified by the aims it hopes to achieve, but it can also be fair and imposed on conduct, in such manner which the citizen has a responsible ground of knowing such conduct to be criminal. 3.2 The notion, idea, of responsibility closely related and germane to the principle of retribution is the notion of responsibility or culpability. This is also because a man deserves punishment only to the degree which he was responsible for his criminal acts. For example, if a person who was suffering from insanity kills another, we do not hang him in return. Instead, he may be ordered to be put in an asylum for observation, and that does not amount to paying him back for killing another, but it is designed to protect other persons from possible future attacks. The notion of responsibility can be said to arise at 3 different stages in a criminal trial. First, the court would decide the straightforward factual issue whether the accused did act or make the omission with which he is charged. Here, doing the act or making the omission conjures the accused person's responsibility. The second stage of the trial is used to describe the finding that not only did the accused do the act or make the omission with which he is charged, but also that in the eyes of the law, he is responsible for it. The third stage is that of sentence. Here punishment may be mitigated, lessened or reduced, on the ground that his responsibility, though proved, was not very great, and at this stage, there are degrees of responsibility. Sometimes, at the third stage, during punishment, there may be diminished responsibility, as when a man steals to feed his starving children, he may receive an acquittal, usually at the discretion of the court. But please bear in mind that you cannot be availed of responsibility, if upon a charge for murder you are pleading provocation. Because the concept of responsibility rests on a reasonable amount of freedom of choice and capacity to regulate one's conduct. A number of controversies have arisen as to the standards of responsibility to be adopted. See Okonkwo and Naish's opinion. See the opinion of Professor Brett in his book An Inquiry into Criminal Guilt, pt 42 at 101. CSS 152. Introduction to Nigeria Criminal LA. W. 89. Further, on the standards of responsibility, Lord Coleridge CJ handed down a dictum which, though leading, was also flexible. For that dictum, see the case of R.V. Duiley and Stevens. 1884, 14 QBD 273 at 288. On the whole, it is argued that it is safer to anchor the standard of responsibility on the standard of an ordinary man. When the standard of responsibility commensurate reasonably well with the standard of the ordinary man, then this ensures that we can plan our lives so as to avoid liability if we are involved in breach of law by genuine mistake or accident. See Section 25 and 24 of the Criminal Code respectively. 3.3 Utilitarian objects of punishment. The point must be recognized that utilitarian principles of punishment are essentially forward-looking. It is forward-looking because punishment is imposed with an eye to its future results, the basic aim being to prevent further crime. There are about 4 utilitarian principles, and to the analysis of these, we now turn. 3.4 Disablement. This is a principle which seeks to disable the offender through the imposition of capital punishment or imprisonment for life. The principle seems to be saying that the more willing is the danger a crime is thought to present, the more willing is the society that the offender be shut off for a considerable time. Thus in R. v. Adibson, 1940, 6 Waker 197. On appeal, sentences imposed after a conviction for armed robbery and burglary, the Court of Appeal increased the sentences of the 2 accused persons of 10 years and 8 years imprisonment respectively to 15 years and 12 years. The court said that for the protection of the public, the offenders should be sent to prison for even longer terms than those imposed by the trial judge. 3.5 Deterrence. This is regarded as the most potent and vibrant principle of punishment, and it takes 2 forms. In the first form, punishment may be imposed in order to deter the particular accused from offending again, or in the second form, it may be imposed with the more general view of deterring the public from doing what the accused did. The court adopted the more general view in the case of State v. Okekukvu, 1965, 9 EALR 91 at 94. In the case, Nkimena J. imposing a sentence of 9 years in a case of manslaughter by a medical quack, said this type of offense is very common nowadays and a deterrent sentence is called for in this case. CSS 152. Introduction to Nigeria Criminal LA. W. 90. Ignorant persons should not be allowed to experiment with the lives of others. It is a truism that the general theory of deterrence runs counter to the notion of fair deserts, earlier examined, than it appears. That more favored judicial approach by the court. Regarding the issue whether deterrence as a utilitarian object of punishment really has the deterrent capacity or the capacity to deter, it may be said that there is concrete fact that some criminals who actually commit crimes are not deterred by fear of punishment, which explains why heinous crimes like robbery are on the increase in spite of the deterrent punishment attached to it. Deterrent punishments are most often imposed on offenders who are believed to be professional criminals, but career criminals are not likely to be deterred by it. It is thus argued that it is not the fear of punishment that deters a calculating criminal from crime, so much as the fear of detection. Okonkwo and Naish submit that the principle of deterrence does not play any useful part in punishment and so should be applied with caution. 3.6 Rehabilitation or form. The essence of this method of punishment is not to punish an offender by imposing some unpleasantness upon him, but rather to prevent him from offending again by transforming his attitude so that he himself will voluntarily refrain from offending again. The most notable method of rehabilitation is probation. Here, the only unpleasantness imposed on the offender is to place him under the supervision of a probation officer, though he is otherwise free to pursue his normal life. The essence of the rehabilitation principle is to build up the offender's personal sense of responsibility. The principle of rehabilitation designed to protect the society, and it is applied most frequently to those offenders who are regarded not to present a very grave threat to the community, but on the contrary for whom there is the greatest hope of rehabilitation, for example juveniles. 3.7 Educative principle closely related to both the deterrent and rehabilitative aspects of punishment is the educative aspect. The essence of this type of punishment is to educate people out of a certain way of behavior which is prevalent. Thus the mere fact that a part of the community denounces CSS 152. Introduction to Nigeria Criminal LA. W. 91. A particular conduct so strongly as to render it liable to punishment will not only deter others from committing it, it will also make them come to see that such conduct is wrong. For example, slavery, when first prohibited, was commonplace in many areas in Nigeria, but at present slavery is relatively a rare occurrence because of the community's attitude towards the practice. 4.0 Conclusion. In this unit, we exposed the fact that punishment is to serve three purposes: rehabilitation, reformation and education of the offender. The tripod on which justice is hung, i.e. justice to the victim, justice to the accused and justice to the society, was also held in a delicate balance by the various themes and types of punishment as exposed by the unit. The effort here is to show that punishment serves a correctional role in our legal system. 5.0 Summary. The essence of punishment is to subject the accused person to some measure of deprivation. These are some underlying principles associated with punishment. A man deserves punishment only to the degree which he was responsible for his criminal act. The utilitarian principle is essentially forward-looking because the punishment it imposes is designed to achieve future results. In disablement, capital punishment is imposed in order to disable the accused from offending again. The